Ryan Brown, and we're going to talk about private warrant applications and the hearings that surround those. So in Georgia, citizens have the right to go to the magistrate court and request and apply for a warrant against another citizen. So if someone suspects that there's been a crime, the traditional thing to do is to call law enforcement and see if law enforcement report the crime to them and see if they'll make an arrest. Sometimes law enforcement may not make the arrest, may not think an arrest is appropriate, or may not respond, or whatever the situation may be. Sometimes they'll even recommend someone do this. But they can, citizen can go to the magistrate court, request an application, apply for a warrant, and have it set down for a hearing. And when that happens, the person that's being accused has the opportunity to go to that court date and defend themselves. It's called a private warrant hearing. And the problem is that you have the right to remain silent during these hearings, of course, but sometimes it is prudent to be there, right? And to hire counsel to try to defend you, because if you lose at one of those hearings, if the person applying for the warrant proves to the magistrate judge that there's probable cause that a crime was committed, the magistrate judge will issue an arrest warrant right there on the spot. Now he or she may be kind enough to give you a turn-in date and go ahead and set a bond depending on the charge, but there can be an arrest happening as soon as that hearing's over. So if you find yourself facing a private warrant hearing, usually you'll be notified in the mail, and it's a scary piece of mail to get. You should definitely contact a lawyer, at least consult with them about what your options are in the process. But that is what a private warrant hearing is here in Georgia.